Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers, and today I'm going to talk about residency and jurisdictional requirements in divorce and custody cases in Connecticut. So I'm first going to talk about divorce. The rules are different than they are in custody. And I'm going to share my screen to show you the relevant statutes. So for divorce, the relevant residency requirement statute is 46B-44. So it says that a complaint or dissolution of marriage, complaint for dissolution of a marriage or for legal separation may be filed at any time after either party has established residence in this state. So what that means is you can file at any time as long as one of the two parties lives in Connecticut. That doesn't mean like your driver's license says you live in Connecticut, but you actually live in Massachusetts. It means you actually keep your primary residence in Connecticut. You can file a divorce. Now, that does not necessarily mean you can finalize your divorce right away. You might have to wait in order to finalize your divorce, and that's covered under subsection C. So a decree dissolving a marriage or granting a legal separation may be entered if any of the following. So divorce can be finalized if one of the parties to the marriage has been a resident of this state for at least the 12 months next preceding the date of the filing of the complaint or preceding the date of the decree. So basically, let's say you've lived in the Connecticut for the last 5 years. It doesn't matter. You've lived there. You can file it. You can finalize it at any time because you've lived there for the previous 12 months. But let's say you lived in Connecticut for 6 months. You can file it under subsection A, but under subsection C1, you can't finalize the divorce until one of the parties has lived in Connecticut in their primary residence for at least a year. So that's subsection 1, but you don't necessarily have to have lived in Connecticut for at least a year in order to finalize the divorce, because there's a couple other subsections. Subsection C2 says that you can finalize your divorce if one of the parties was domiciled in this state at the time of the marriage and returned to this state with the intention of permanently remaining before the filing of the complaint. So let's say so under this, you have to have lived in Connecticut at the time of your marriage. Doesn't matter where you got married. You could have gotten married in New York, but if you've lived in Connecticut at the time of your marriage and you moved to, let's say you and your spouse moved to New York, and then you returned to Connecticut if you've returned to Connecticut before you file the divorce and you have the intention of permanently staying in Connecticut, you can basically move back to Connecticut, plan on permanently staying there. You can file the divorce. And as long as you met those requirements, you can finalize the divorce. You don't have to wait the year. As long as you've lived here at the time of the divorce, you came back prior to filing with the intention of staying here permanently, you can finalize your divorce in less than a year. The third subsection is that the cause of the dissolution of the marriage arose after either party moved into this state. So let's say both of you lived in New York and, 3 months ago, you moved to Connecticut. Let's say your husband stayed in New York and you moved to Connecticut. Well, you can, of course, file for divorce because you're living in Connecticut. But maybe when you moved to Connecticut, you were planning on keeping your marriage together, having a long distance relationship. So you were planning on keeping the relationship together, but the cause of the dissolution of the marriage arose after you moved into Connecticut. So, the long distance relationship didn't work, communication broke down, the cause of the breakdown happened after you moved to Connecticut. You can finalize your divorce without having to wait a year. Or let's say, you lived in New York and then both of you moved to Connecticut 3 months ago, you get into a fight, something happens that leads to the demise of your marriage. You don't have to wait a year because you can say that the cause of the breakdown of the marriage happened after you moved to Connecticut. So those are the residency requirements. If you don't meet subsection 1 or 2, you can usually finalize your divorce under subsection 3, because, you know, the cause of the dissolution of the marriage can be pretty wishy-washy. You might be able to say that it, you know, it didn't arise until after you moved to Connecticut, if you lived here for less than a year, in which case you can, you know, you can finalize your divorce. So that is the divorce residency requirement. Now I'm going to shift gears and talk about custody, because, you know, divorce is a little different than custody. So custody is, you know, determining what the parenting plan is going to be for children, etc. So custody is governed by the UCCJEA, which is a uniform kind of jurisdictional procedure that's followed by, I believe, every state. There might be one state that doesn't follow the UCCJEA, but it's a uniform jurisdictional law that governs every state. And let's go through this as far as determining who has custody or who has jurisdiction over custody. So a court of this state has jurisdiction to make an initial child custody determination if any of the following. And this is to make an initial custody determination. So if there's already existing custody orders and you want to modify them, for example, that's governed by a whole different set of rules, and I'll create a separate video that talks about that. So Connecticut has jurisdiction if subsection 1, this state is the home state of the child on the date of the commencement of the child custody proceeding. Now, you have to be careful in knowing what the definition of home state is. And the definitions are governed by 46B-115A. And that says that home state means that the state in which a child lived with a parent or person acting as a parent for at least 6 consecutive months immediately before the commencement of a child custody proceeding. In the case of a child less than 6 months old, the term means the state in which the child has lived from birth with any such parent or person acting as a parent. So basically, you know, more or less, it's governed by where the child has lived for, you know, 6 consecutive months. So if you lived in New York and you've moved to Connecticut and you've lived in Connecticut for 3 months, Connecticut does not have jurisdiction over custody until you have, you know, you can't initiate a custody proceeding in Connecticut until you've lived here for 6 months. And there's going to be some exceptions to that, which we'll talk about below. But, you know, so if it's where the child has lived for 6 months. Subsection 2 is this state was the home state of the child within 6 months of the commencement of the child custody proceeding. The child is absent from the state and a parent or a person acting as a parent continues to reside in this state. So again, the example I gave, you know, if parties are living in New York and move to Connecticut and have been in Connecticut for, you know, 3 months, that's not the greatest example, because if they've been in Connecticut for 3 months and nobody is still living in New York, then Connecticut has jurisdiction. But if let's say mom moved to Connecticut with the child and has been in Connecticut for 3 months, but dad still lives in New York, dad can initiate a custody proceeding in New York. Connecticut does not have jurisdiction until the child has been residing primarily in Connecticut with mom for 6 months. And that goes the other way. You know, if, you know, let's say the parties are living in Connecticut and one of the parents moves out of state with the child for whatever reason, you know, moves to New York. If no custody proceeding has been filed, the person who stayed behind in Connecticut can file a custody proceeding in Connecticut for 6 months. They have 6 months to file it. If they wait longer than 6 months, you've given up jurisdiction to whatever state the child is in. So it's important to be mindful of the timing on that. So just to read over subsection 2 again, this state was the home state of the child within 6 months of the commencement of the child custody proceeding. The child is absent from the state and a parent or a person acting as a parent continues to reside in this state. So again, that requires one of the parents to still live in the state that the child moved from in order for that state to still have jurisdiction for that 6-month period. Subsection 3 says that a court of another state, that this state has jurisdiction if a court of another state does not have jurisdiction under subdivision 1 or 2 of this subsection. The child and at least one parent or person acting as a parent has a significant connection with this state other than mere physical presence, and there is substantial evidence available in this state concerning the child's care, protection, training, and personal relationships. So that generally will encompass the situation of, okay, the home state is technically still New York. If, the parties were living in New York and they moved to Connecticut for, 3 months ago. Under the definition of home state, New York is still the home state, but neither of the parents lives in New York anymore. So, the case would then be handled in Connecticut. So, so those are the basics. Let's see what subsection 4 is. A court of another state, which is the home state of the child, has declined to exercise jurisdiction on the grounds that this state is the more appropriate forum. So that can happen. Let's say the home state might, for whatever reason, say, we don't want jurisdiction. We, Connecticut, don't think we should have jurisdiction. New York is a more appropriate place, or vice versa. We, New York, don't think we should have jurisdiction. Connecticut is a more appropriate place. That can happen as well. But generally speaking, it is where the child has lived for 6 consecutive months, unless neither parent is in that state where the child lived before. So those are the basics on the difference between divorce. There's divorce jurisdiction and custody jurisdiction. So you might be wondering, okay, well, what do I do if, there's divorce, the residency requirement is met in Connecticut, but, the custody requirement has not been met? Well, those can be bifurcated from one another. So technically a divorce could be handled in one state. You might file for divorce in Connecticut, but if Connecticut does not have jurisdiction over custody, the custody proceeding could be handled separately in New York. Now, that would probably be a big headache, and I'm not sure you would want to do that, just because it would become expensive and cumbersome to be operating in 2 separate courthouses. So it probably, from a practical standpoint, makes sense to be filing the divorce, in the state that has jurisdiction over custody, if you do in fact have children and custody is going to be in dispute. So those are the basics on the residency and jurisdictional requirements in divorce and custody cases. If you have any questions, as usual, feel free to contact our office and we would be happy to answer any questions you might have.